is clearly information that's disclosable or that should be available to any member of the public, particularly to residents who live within the jurisdiction of that government body. If the district has its way, the public would be precluded from knowing the total amount of income that the district takes in a given year. That would be an absurd result. With respect to the information contained in the 1096 forms, Section 6103 does not prohibit access to information that may be obtained independently. Not only is the district reading the statute to cover tax filers, people who file their own taxes, and the district as a tax filer, but it is extending the reach of that statute to preclude the district from having to disclose records that contain information that might be on a 1099, such as the amount spent on maintenance and things like that. One thing that shows what's so bizarre about the district's position in this case goes back to Category 3 and Category 4 of the denials. Council stood up here just a moment ago and said that they would be willing to disclose the name of the people who performed work for the district, but not the amount that the district paid for the work. Well, a 1096 form and a 1099 form would clearly include both of that kind of information. So I think the court correctly pointed out that the district seems to be selectively choosing what to disclose and what not to disclose under its broad reading of 6103. And if you pay attention carefully, the types of information that they're trying to preclude my clients from obtaining relates to the amount of it, to expenditures and to the amount of money spent, to the amount of money taken in by the district, basically things that would be able to show whether or not the district is corrupt or whether or not the district is operating properly, whether or not the district has in fact authorized every expenditure of taxpayer dollars that the district has spent as reported on these forms and things like that. So that's what I wanted to say about the 6103 argument and the overly broad reading that some federal statute that quite clearly only governs the IRS and other government agencies that obtain tax filings somehow applies to the tax filer. That's just a bizarre reading. I think that's all I have, Your Honor, unless there are any additional questions.
Could you address the argument about the legal bills and the proposed redactions to the legal bills?
Sure, Your Honor. Well, first, our filing makes clear that we would be willing to accept redactions if that's something that the court thinks is appropriate. We certainly recognize that legal bills, we don't know if these specific legal bills do, but certainly recognize the possibility that legal bills may contain privileged information or confidential information. But our opinion is that with the very least with respect to how much the district spends on legal matters is not something that's confidential or would be protected. We also know for a fact that the district has many times in the past disclosed its legal bills, possibly with redactions, but again, we'd be willing to accept redactions. But our clients want the maximum amount available to them, even if there is privileged information in those records.
Right. Thank you, Mr. Sunburst.
Sure.
Both sides have gone over a little bit, but Mr. Lynch, I'll let you reply as I indicated briefly.
Thank you. As to the legal bills, the issue here, Your Honor, is whether they have now had a change of heart, but the complaint was premised on an improper representation in that they had denied, Mr. Jones had denied my offer to examine legal bills for necessary redactions and then provide them to the district to have him examine or copy. That's what the complaint's based on.
Well, to the extent that they're telling me now that appropriately redacted materials are okay, shouldn't I simply order that the legal bills be produced with redactions and a privilege log for those redactions?
But that's not the complaint, Your Honor. The complaint is that they're entitled to the legal bills, period.
So I can either only give them the legal bills or not. Those are my two options according to you?
Well, no, Your Honor. I mean, we can give them the legal bills if they want them redacted, but the complaint is based on getting the legal bills without redaction, i.e. waiving attorney-client privilege. We believe that count is improper on that basis because the district's not required to waive its attorney-client privilege. The district offered redacted bills, so they rejected them. they based their complaint on their position that they were entitled to the bills.